Yep. Good evening, everybody, and welcome to Barnsley, to this wonderful miners' hall, which the NUM have kindly allowed us to use for tonight. The purpose of tonight is just to bring people up to date with the Employment Rights Act 2025 and the changes that are starting to drip feed through and the importance of those changes. We are fortunate that we do have a Labour government, because if we didn't have a Labour government, we wouldn't be getting the changes that we're talking about tonight. And as the night goes on, you will see how important these changes are and how the trade unions need to embrace these changes, and we need to build on these changes to get ourselves ready for the future. Because as time goes on and different governments come in, there's no saying what will happen. So it's important that we get all this legislation up and running and we start delivering on it. We start using the legislation straight away. So without me messing about anymore, I'm going to hand over to Chris Kitchen, the General Secretary of the NUM. And Chris is going to give us a little bit of background on the importance of this and what it's actually delivering to start with. And then we'll be handing over to our solicitor, David Sorensen from Morrish Solicitors in Leeds, who will be taking us through the Act and putting a timeline on things, on what's coming when. And when we get to the timeline, it's really important that you follow it, because it's not a one-size-fits-all. There's going to be various bits stripped in at the same time. So without further ado, Chris Kitchen.
Thanks, Phil. I think it's important for us to look back at how we got to the Employment Rights Act. And obviously, Labour in opposition recognised that there was an imbalance between the employer and the employee, and put in the manifesto to address that balance. A lot of the rights that come in aren't exorbitant rights, you know. Day one's right to sickness pay, the ending of 0-hour contracts, so that people get a contract that reflects the hours that they actually are working, not some fictitious hour. And also that the people can then start to plan their lives. They've got some little bit more security. The insecurity of work over the last 14 years of the last government meant that people couldn't plan. They couldn't bring up a family, because the bedrock is that you go to work, you earn the money in order to improve your life for yourself and your family. And I think one of the main things that we missed on that was actually people not being able to improve their lives. It started off in the manifesto to address the imbalance. There's a lot of parts of the Act that still have consultation, and unfortunately at the moment, a lot of the consultation seems to be more like a negotiation, where because they're trying to strengthen one part of the employment rights, they're trying to water down the other right to maintain the status quo. That was never the point of the manifesto commitment. The manifesto commitment was to strengthen the rights. And I think it's important that we do publicise through trade unions, through workplaces, what these rights are. But having a right doesn't automatically benefit you if you're not able to exercise that right. That is where the importance of trade unions plays into this. That if you're a part of a collective, a part of a trade union, that they can support you to make sure not only that you've got the rights, but you can impose those rights and exercise them. I think what most people need to remember is any decent employer that treats its employees with respect has nothing to fear from the Employment Rights Act. It purely puts a legal obligation to do what many of them are doing already anyway. It's the unscrupulous employers, that want to exploit workforce that they've got to try and increase profits. It's those that are kicking off about a lot of the legislation changes, and that's to be expected. If you're going to improve the employment rights to benefit the employees, then some of these that's been taking advantage of the employees are going to be adversely affected, and they are going to keep their. I think that the back of my mind is always one main point. Being able to go to work is important. It's good for you, it's good for your family. It's good for society in general. But if you're going to go to work, you must be able to earn a decent amount of money that affords you a decent standard of living. It's totally obscene that we've got people that are working for a living that are having to rely on in-work benefits to make ends meet, especially when someone are working for companies that are making money hand over fist and can quite easily afford to reduce their profit margins and pay a decent level of wage for the work that their employees do that generates that. So I think with that said in the back of the mind, I'll now like to hand over to David who will go through more of the technical details of what the Employment Rights Act is, what the new benefits are that people are going to get. And like I said, if you're part of a trade union, it's a lot easier to access those rights if they're infringed. So back in there.
Good evening, everybody, and thank you hugely, Phil and Chris, for those words, really important words on the Employment Rights Act. I'm going to go through some of the technical detail, but I also want to give a little background to it. And if I can just pull up my slides, we can have a look at what we're going to be looking at. I should also say it's wonderful to be here in such a historic and important venue and talking to you all. The Employment Rights Act, we hope, is also going to be a historic and important set of legislation. And if we could just move the slides on a little, we can just have a look at what we're going to cover, as well as give a little bit of background to it. Just to explain, I'm from Morrish Solicitors in Leeds. We've been acting for unions and associations for many years now. I've been around since 1882. Sometimes I feel as though I'm still starting my first day in 1882, but not tonight, because it's really pleasing to talk about something that's transformative and really positive in terms of the changes we can get from the Employment Rights Act. So if we just move on a little bit beyond us and also our services, solicitors of course, and we cover all kinds of legal services, but then we'll move on from the sales and go straight into the main event and the Act itself and move through. So, as Chris was saying, and Phil, this is a flagship Labour government programme. I've been an employment lawyer since, certainly the 1990s, and obviously been a lawyer through many changes of governments. And the governments that we've had are quite clearly Labour governments move employment rights forward, and Conservative governments, also remember the Lib Dem coalition as well, to move them back, and in terms of union rights. And here we are looking with the Employment Rights Act, with everything involved within it. We're looking at moving employment law and all aspects, including union rights, forward, sort of the biggest single transformative change in one go. Some people, some commentators have said it's the biggest sort of change in a generation. I go further than that. It's the biggest single change in terms of all the changes that are coming in. And importantly, it's also part of the government's growth strategy. So the intention is to support strong trade unions, to improve wages and earnings for working people, and also to use that as part of the growth of the engine of growth of the country. And I should also point out that when we assess where the country currently is in terms of employment rights and health and safety, there is an international ranking by the OECD, and we are third from the bottom of the largest economies of the world. We're just above, just above Canada and just above the US. And the intention really, and the prediction is that when all these changes come through, we will move to the mid-table level of those large economies. There'll still be economies that have better employment rights and protections, for example, the Netherlands, but we'll move up to a higher level. And part of that will not only hopefully pull up wages and employment rights, but will also make us a stronger economy and, importantly, improve the protections so that when some of the large multinational companies look around the world or the big economies to make redundancies, say, they may no longer say, not the United Kingdom, well, the right to grow and then people are more protected. So we can have hope, because of course we're familiar with many horrible instances where this country has been chosen simply because some of the big international players think it's cheaper and more cost effective to make job cuts, to close factories, make those changes here. And the intention here for the Employment Rights Act is part of that is to improve those protections. Now, what's it going to do? Well, the other point to make is, as well as those sort of hopeful improvements, the intention is it will benefit around 18 million workers and also proportionally benefit female workers as well, in terms of bringing many workers into basic employment rights. So that will be a real difference. The other point I should make is there's a lot coming with the EO. There's lots of aspects to it. And I think the government have not always put out the best message on it. And it's a shame because it really is positive. And when we you drill into the detail that comes from the government, they are very supportive. They're very supportive of the unions. They see the benefit. They see the unions' praises, quite rightly, as protection for workers, helping grow the economy. So that's all clear. But unfortunately, that message doesn't always get through. And partly maybe because there's so much coming, and it's quite hard to pin down. So what I'm going to try and do is look at the timeline of changes, and then looking ahead into the future. And Chris has really helpfully mentioned negotiations for civil servants. And of course, the things that haven't come in yet are in that sort of sphere where they're being negotiated, where they're being discussed. And we, as a movement, and as trade union lawyers and trade unions, need to push for those changes to come in. The good news is the majority have so far come in as intended. We'd like more, don't get me wrong, we'd like more, but what we've got, again, is still very good. We need to acknowledge that, I think, and it's important to do so. So if I can move on to the next slide, and then what I'm going to just talk about is the things that have already come in. And just to pause before I lose my track, but the changes are coming in and have started in February of this year, moving into a chunk of changes that came in April, and then we're looking at more changes coming through later on in the autumn, into the winter, into 27, and then more coming through, with a package, hopefully, of changes coming all the way through into late 2027, and possibly, now hold on folks, but possibly with more in reserve, we hope, maybe in 2028. So again, I may be a little bit over optimistic, but I think I'm a cautious promise that if we can push all these changes through, we'll get some more maybe in 2028. But of course, as Chris has said, and has been said earlier, that there's been a pushback from business, and certainly the sort of right-wing or right-leaning media in terms of a negative impact. But overall, when the assessments have been done, the economic benefit of bringing in the changes outweighs the employer costs of the changes. So that is clear. That's been identified. So it is an improvement. Anyway, I'll get back to what I was going to say and look at the changes that have come in. So we've had the first changes were in February, and we've had a number of changes impacting on industrial action. So making the industrial action machinery work more effectively, make it less of a burden for unions. The government have wound back the clock effectively to 2016. So we, as a country, still have quite a bit of trade union legislation in terms of industrial action, authorising that balance. So there's still quite a lot of hurdles for unions to go through, but it's better than it was under more recent Conservative governments. And also, these are sort of relatively small changes that will have a big impact. There's protections strengthening unfairness for taking industrial action. Because ultimately, taking industrial action, being able to go on strike, is a fundamental right. And therefore, the individuals who do it, who bring big on strike, or take action short of the strike, need to be properly protected. So the unfairness of protections have been strict. And then if we move on a touch, we get into changes in April that are really important. So the increases to basic statutory rights like national minimum wage have had higher than usual increases. And importantly, SSP, statutory sick pay, has now been expanded so it covers more individuals, more working people, and it becomes a day one right. The idea really that individuals have to work 1 or 2 days before getting basic SSP has always really shocked me, and now it becomes a day one, which is really important. And like I mentioned, also protection against unfairness, there's some protections there as well. So these are quite significant changes, but when it's been looked at as to the most impactful changes coming over the next year, SFP changes are going to be quite significant, expanding, and that will be many employees, working people will have protection, and also proportionately more female workers as well will now be covered by SSP protections. And if we could just move one more forward, we then get into the other changes that have been made. So again, there's a mixture here. It's a real mixed menu, but that's because different areas are being strengthened. And so sometimes it's quite hard to keep track. And some of these may on the face of it seem quite small, but actually they are quite significant social changes too. Because day one rights are coming in for paternity, have come in for paternity leave, and ordinary unpaid parental leave, and increased statutory family pay, and also bereaved partners paternity leave, and some menopause guidance, gender pay gap action plan. So these things, again, there's a mixture here, but all of them are benefiting working people. And lastly, again, a number of people might not be familiar with protective awards, but this really is the compensation when a large employer makes multiple redundancies and doesn't go through an adequate information and consultation process. Now, again, that is often the big employers. We think of people like P&O and other big employers who may not adequately inform consultant again, so we can cover the cost of it. We'll pay that, not worry about complying so much. Here, they're doubling the protective award payment. So suddenly, that's a much increased cost of effectively about half a year's pay per person if somebody is dismissed and the employer hasn't collectively consulted with the union or the employer representatives, that kind of body. So really important, and this is the start of some rights coming through to protect mass redundancies, restructuring situations. So start of that process. There's more coming, but it's a start. So there we cover the main changes in April, and I think if we move the slide on, we just look into, there's of course, slightly later in April, an organisation called Fair Work Agency. So this is the first time that different elements like national minimum wage, enforcement, holiday pay, other aspects are coming under one umbrella. It's a new body, it's been formed. We're yet to see it sort of tested in battle and how strong it will be. But if it works with unions and it works with working people to enforce their rights, it could be a really successful way of moving forward. But it's going to be down to public, it's going to be down to support. We're yet to see that tested. But again, a positive development, bringing in the different groups, things like gangmasters, the legislation, enforcement, national minimum wage, other aspects as well, under this like a labour market body. So we'll see how that develops. That's another April Easter present that arrived. And then if we move on one more, we start looking to the rest of the year. So there's a bit of a pause, but then there's some heavy traffic coming down the pipe later on. So a number of these aspects are under consultation at the moment. So the government have released consultation documents, unions, lawyers, working people are responding to it. Please do, it's really important that the civil service and the kind of government machinery get the feedback on these changes, so we can ensure that the changes are as union and worker friendly as possible. So what we've got coming down are, again, a sort of mixture of aspects, but all together, it's building up a picture of stronger employment protections. So we've got stronger protections against workplace harassment. That's bringing in the requirement on an employer to take all reasonable steps to prevent it, to train the staff and so forth. There's protections against third-party harassment. The intention there is when individuals who are colleagues visit the workplace, protections against workers there. So that could be delivery drivers, that could be other contractors and so on. Again, waiting to see more. A right for the employer to provide written particulars of employment, identifying the right to join a trade union, again supporting unions in the workplace. Trade union access, and this is a big potential change. It's quite a complicated area. We want to make it as practical as possible, and so we need to see more depth to this right. The feedback, I think the Daily Mail newspaper referred to it as the trade union right to roam, which is not true because it's a right of access and request access. But we want more there, we want more strength on that. That's an area I think we can strengthen to get improved access. We're also looking clearly at improved rights, facility time and time off for representatives, including equality representatives. So bringing in equality representatives to help support the workplace and help reduce harassment in the workplace. So again, another example of trade union involvement, investment in the workplace, with government support there. And then some important changes to public sector outsourcing, because we're all familiar with the horrors of transfers of workers in and out of different organisations and the impact that can have in 2, 3, 4, 5 tier workforces. So this is the intention to improve and reduce the 2-tier workforce and bring harmony between those transfers in and out. And then one that is personally really important to me, the extension of employment tribunal time limits. Because as an employment lawyer, we've been working with 3 months time limits for how many decades? And I can assure you, if we had a 6-month time limit back a year ago, I would have a full head of hair. I would not have suffered half the stress I have because of the tight 3-month time limit. So hopefully, again, a 6-month time limit, just to give a bit more time to try and negotiate, to try and resolve, get union involved, and try and settle disputes before they may have to go to tribunal, so just giving more time. And then lastly, another kind of interesting piece of the menu, but reforms to tips and gratuities, because the hospitality sector, I can certainly think of friends and even children who sort of worked in that area, the tipping process is often very complicated. Nobody quite knows. The intention here is to improve that, bring some daylight, hopefully release tips to the workers that may be received currently. So some improvements there. By I think the range of stuff we're dealing with, you can see the government have put a lot of thought into this. I can certainly say from a legal point of view, they've been extremely well organised in the way it's been brought in. Again, the communication could be improved, and it's really a great shame that it's not as well communicated. This is also part of the process tonight to try and get this message out there. The communication could be improved, and let's hope word is spread. And certainly we want to be part of that. But the range of changes and the organised nature of it is coming through. So we then look, so we've got to the end of 26, and we're looking at 27. Christmas has been and gone, but we then see some more big changes going. And the first one is fire and rehire. I won't go into too much detail on this right now. The intention is to improve protections against large-scale fire and rehire, changes to contracts, preserving terms and conditions. There's consultation currently underway on aspects of that, but it looks good so far, and it does mean that in practice, as it comes through, it will make it much harder for an employer, for an organisation, to adopt a fire and rehire type strategy. Again, giving more employment protection in practice. We've also got collective redundancy consultation. So we talked earlier about protective awards, and when there's a proposal to dismiss 20 or more at one location, typically, what we're looking at is expanding that so it can be across an organisation. So that actually there could just be one individual certain location, but the 20 or whatever number it is when it's decided covers different locations, bringing that protection down to the ground on small sites, not just the big sites, but smaller sites that may have a small number of people. So we're waiting for that kind of detailed consultations, either closed or about to close, in terms of that information and how that works. So we really need to keep an eye on it to make sure it's a practical benefit that strengthens that protection. And then the next one, and it is a big one, is zero-hours contracts. They are not being banned completely, but the intention of the government is to try and legislate to make them work in a fair way. I'm a bit concerned here that it's too complicated. We'll see. There's a lot of detail to where it's going to work. But the intention is to give guaranteed hours, a kind of much more structure to working, because currently, obviously, as we know, most people are working 0 hours or in those kind of flexible hours, no certainty to when they work. Difficult to get to rent a house for property, difficult to get any kind of financial information, stability, and it can be so impactful. So the intention is to give more certainty. Ooh, quite a bit more. Agency workers, protections, improving those, looking at bringing in for the larger employers mandatory menopause and gender pay gap action planning, so requiring the larger employers, I think it's 250 plus employees, to bring in those plans to improve that in the workforce. And then a very large change, which is the unfair dismissal change. So this is reducing the qualifying period and also removing the compensation gap. So that will make a big change to it. It does mean that unfair dismissal protections will increase, which is wonderful to bring in those protections, because as Chris said, most employers, good employers, reasonable employers, will carry out those kind of processes. Will act fairly, have disciplinary hearing, will go through that process. And this will expand that, particularly a big catch up, the less good employers that need to be qualified. So that as the time rises, hopefully all ships rise with it. So that's a big change. So in terms of the most impactful changes from the research that's been done, it's SFP, it's the extension of unfair dismissal rights, so that the 2 readings, there was an awful lot of other important changes as well. And if we could just move on to those, I think we've got a fair summary. There are some other changes in 27 which will bring improvements and fair pay agreements in the adult social care sector. There's looking at a kind of sector-wide regulation of payment terms and conditions, which is hoping to bring improvements there in social care, which is an area that really needs attention. So this is looking at sort of extending bargaining across that sector, which is a good start. I'd like it to have started earlier, but it's good that it's happening. It's down for next year. And then if we just move forward one more, I think we look at the last change in 27. So some other changes in terms of protections, bereavement leave itself, then looking at improvements to flexible working rights, so to make it in practice harder for an employer not to give consent to flexible working. And then lastly, non-disclosure agreements. Again, one of those kind of terms, but as we know with the Me Too movement, and various very upsetting scandals that have happened in terms of harassment in the workplace, the government are tackling the use of non-disclosure agreements, gagging agreements, as they're often called, and restricting those more than they currently are. They have made some changes already, but looking at bringing other changes to ensure that those are much more limited in use, which again is part of the changes. And then if we move forward, we then have potential other changes coming through as well. So I mentioned some other things, but there's a look at possibility of equal pay changes applying to other protected characteristics, and some other changes in terms of fair pay agreements, and other changes to competition and non-competition clauses and things like that. So there's a number of other changes in the discrimination sphere as well. We're waiting more detail on those, but that's something to bear in mind in terms of changes coming later in 27 or possibly 28. And then if we just turn to looking beyond 27. So we've had a bit of a helter-skelter ride through all the changes, and I'm sorry to sort of do it with such speed. I think it's important to try. So I'm trying to fit it all within the presentation. So we've got a number of significant changes, and then we look beyond 27, and there's some other potential things as well. There's the possible right to switch off. This is something that was flagged up a couple of years ago by the government under consultation, where some jurisdictions have said, for working people, electronic iPads, iPhones, laptops turning up at a certain time, and that is still a possibility. So that may still happen. So we need to keep an eye on that. We're then looking at a possible statutory collective agreements procedure, where groups of grievances can be brought together, most likely with union support to bring that forward and helping that to try and resolve disputes in the workplace. We're looking at the big potential change, and it could be the biggest, of a single employment status. Because currently we have effectively three sort of levels of status: the employee, the traditional, the worker, the sort of in-between area where the worker is still entitled to benefits, minimum rights, like national minimum wage, holiday pay, and then the genuinely self-employed. So this government are looking at potentially bringing the worker and employee into one group. If that happens, that would potentially be all on worker rights. That would extend employment rights most significantly. It is a big one because, of course, it rubs up against the tax system of employee and self-employed. So it's one that I think many governments have looked at, scratched their heads and gone, oh, that's just too difficult. We'll leave that to next time. So we will see how the current government tackles. But that could be a real significant change. But it's a big change. And then we've got a couple of other areas in terms of the sort of shift towards sector level involvement and sector level collective sort of regulation in terms of fair pay agreements and other aspects like that. And then increasing union access rights and other collective rights. So there's a number of other union changes involving the internal running of unions and in terms of union protections. There's potential changes against blacklisting as well to strengthen, so that, for example, covers AI protects there. So there's quite a bit else coming through. I think if we just turn to the next slide, you could just see our QR code and details of our newsletter. There is an awful lot to keep on, and this is a little bit of a plug for us, but please do join our newsletter. Please do check the QR code. We are regularly updating things as the changes come through, and it's really important to resolve these up to date as possible. Keep an eye on the changes that are coming through. The proposals look good for the future changes, but things will move around a little bit, no doubt, as legislative time allows and parliament allows and so on. But please do feel free to jump on that and join us so that we can provide you with regular updates and changes for the next couple of years. But I suppose to conclude, really, I'm happy to discuss further and answer any questions. But to conclude, I just want to make the point that after how many years of Conservative government since 2010 to the change, the recent change, right for the recent change of government, we had many years from trade union lawyers' point of view of very limited pro-employee, pro-union, pro-worker legislation. This is the big, like I said, biggest single package all in that's coming through, and it's wonderful to see these changes because these changes will have an enormous impact on working people, on families, on society, as hopefully these rights pull people up. Increase, the money in people's pockets, hard-working people, and improve their rights as well. Greater stability, which will flow from. So the rights overall are a really positive change, and I think if the government continue to push through the changes that come through in 26, 27, and 28, it really will make a huge difference and be such a shocking and a somewhat. A little bit of a cynical employment where you can get, I suppose, when you get a bit jaded from different governments and previous governments and the kind of the weak kind of porridge we had coming from the Conservative government. It's great to see a really sort of healthy set of proposals and changes that have come. So the changes have already been made. So that, I think we can be optimistic. Thank you.
Thank you, David. Very informative. As an officer of the union, I've had to sit through many webinars in the last few months, And I must admit, thank you for that presentation, and thank you for putting it into a context that makes sense to us and not just solicitor jargon. Because all too often when you attend these webinars, you get the facts, and sometimes it's nice to get the perspective as well. So thank you very much for that. Scott, do we have any questions? No? In that,
Thanks very much.
in that case, all it needs for me to do is to just sum up a little bit. Sorry, there's some questions in the room.
Is this going to have the potential? Here, it's micro figure.
Yeah.
Is this going to have the potential to benefit those particular groups of workers, like maritime workers who are regularly paid on a minimum wage, for example? Is it going to have any genuine impact on them?
It will have an impact on them if they're employed in this country. The fact is that there will still be areas of the international law. There will still be areas of the international law where whatever country the vessel is registered in, that will be what happens. With regards to our own maritime laws, there is sweeping changes going ahead at the moment, because David touched on some of the timelines there, the employment law, 3 months less 1 day. In maritime law, it's completely different. My union has a case going on at the moment where we're supporting a family, somebody who unfortunately lost his life at sea. And the differences between UK employment law and maritime employment law is really different, and the timelines are much shorter. But there is a big review going on at the moment, and hopefully these things will align as time goes on. But to answer your question shortly, there will still be differentials. The likes of P&O, what they did is less likely to happen if they already employ a UK crew, because the penalties will be twice what there was at that period in time. So hopefully it'll deter employers like P&O from doing things like that. But as we know, they now have crews registered in different countries. So will you see an immediate impact? No. Hopefully though, as time goes on and as maritime law starts catching up with UK employment law, there will be some areas where it will improve. Anything else?
I want to talk about the paternity leave requirements and how well they apply, because we have a relative where the baby was born early, and that makes quite a difference for them, and so the father absolutely has to take this leave, but the unscrupulous and dreadful employer indeed insisted on taking back the wages and the sick leave that have been sort of granted, instead of paternity leave, relevant to that point.
Do you want that one there?
Yeah, absolutely. No, they're starting the same changes. That is being strengthened. So there are changes made in April, and then there are more changes coming that will help there. So that's obviously a really difficult situation.
It's like early babies.
Yeah, and also I should say, which is, I mean, because one thing that's always told me over the years is that often those with babies, those who've got taking family and friendly leave, I can call it that at different times, are often facing difficulties in the workplace. And one thing, an area of kind of persistent discrimination is things like pregnancy and maternity related, parental leave related discrimination. Those cases are still kind of consistently coming through the employment trials. And the changes that are now being made, that started in April, will improve those rights. And also the rights of those returning to work and those who may experience poor treatment as a result of taking the family-friendly leave. So it's sort of so to cut the long story short, it's extending that protection, the window of protection for those individuals. So it's quite a bit of detail coming through. And what I can also do is certainly slides as well, which have more detail setting out those specific areas. But it will make that situation better, without it.
There is some specific legislation coming through as well relating to miscarriage and stillbirth. So they're looking at the whole aspect of enhancing rights for people who are unfortunate, suffer that type of thing. I think it's important to say that this is one of the areas where the Labour government is really delivering on its manifesto pledge, and it is improving all the workers' rights. And whatever our relationship with Labour Party is in future, we can't get away from the fact that from a workers' perspective, the Employment Rights Act is one of the better things that any government has done for a long, long time. And the way that they're enshrining it in law will make it more difficult for people to come in and make immediate changes like they have done in the past. So it has been well thought through, and hopefully it will reap a lot of benefit. The sad side of it is that in my day job, I have seen employers taking action now because they know they won't be able to do it in a few months' time. But you will always get employers who act like that. The good thing is that is going to be curtailed in time. Thank you very much, David. Thank you very much, Chris. Thank you with Barnsley IT, the whole committee who helped to put this together, Catherine in particular. And thank you to Scott Aslam from TWU, who has been live streaming this for us tonight. His technology and his expertise is greatly appreciated. There is an event here in Barnsley on Saturday, on the 2nd of May, where the NUM along with Unite will be putting a parade through Barnsley, celebrating the centenary of the General Strike, 1926. Please come along and join us for that. And then the week after, the 9th of May, second Saturday in May, it is Banners Held High in Wakefield. We have a full day of events planned there. We have our march through the town. We have several General Secretaries speaking that day, including Chris, Sharon Graham, and a couple of others. Please come along and support us. It is a genuine trade union movement, and it is only the trade unionists coming along on that day that makes it worthwhile. An awful lot of work goes into preparing for it. We've been really lucky with weather for the last few years, so fingers crossed we carry on that. And thank you very much for joining us tonight. It's appreciated. Thank you.